He was facing up to 20 years in prison for aggravated assault with a deadly weapon. But instead of sending him behind bars, Judge Stephanie Boyd offered something far more difficult: a second chance. The catch? One wrong move, and he could lose everything.
7283, State of Texas versus Philip Nelson Moser. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Robert Maurer for defendant, Your Honor.
And are you Mr. Moser?
Certainly.
All right. Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moser, showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Moser, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Moser, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. There's to be restitution, if any, to N-O-E, Lopez, and there's an affirmative finding of deadly weapon. Did you understand that to be the plea?
Yes.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Noe Lopez and Maria Pena, no firearm possession, and regular UAs. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
State Officer Exhibit Number 1 with all its attachments, Your Honor. No objections.
Mr. Moser, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same.
A Texas courtroom fell silent as Philip Nelson Moser stood before Judge Stephanie Boyd facing a charge that could change the rest of his life. Aggravated assault with a deadly weapon. A second-degree felony carrying a punishment range of 2 to 20 years in prison and a fine of up to $10,000. From the very beginning of the hearing, Judge Boyd made sure Moser understood exactly what was at stake. Every question she asked carried the same message: This was not a minor mistake. This was a serious violent offense with life-changing consequences. Moser entered a no-contest plea and requested deferred adjudication, a form of probation that would allow him to avoid a felony conviction if he successfully completed all court-ordered requirements. The court reviewed the evidence and found there was enough proof to find him guilty. But instead of immediately convicting him, Judge Boyd considered whether he deserved a chance at redemption. His attorney argued that since the case was filed, Moser had taken anger management classes and worked to address the issues that led him into court. He also explained that finding stable employment had been difficult while the criminal case was pending. Then Judge Boyd began asking questions, not just about the case, but about his life. She asked where he lived, whether he had children, and even about his cat, Arjun. What started as a light-hearted conversation quickly shifted into something more important. Judge Boyd wanted to understand whether Moser was prepared to move forward responsibly. After hearing from him, she made her decision. The court granted 5 years of deferred adjudication. That meant no prison for now. But freedom came with strict conditions. A $1,000 probated fine, 200 hours of community service, regular reporting to probation, random drug testing, restrictions on employment, a ban on possessing firearms, and absolutely no contact with the victims. Judge Boyd made it clear that probation wasn't a reward. It was an opportunity. Then came the moment that defined the hearing. She offered Moser a way to reduce some of his community service requirements if he pursued professional certifications and improved his career prospects. Her message was simple. If you're serious about changing your life, prove it. Judge Boyd wasn't interested in empty promises. She wanted measurable progress, education, employment, and accountability. Before ending the hearing, she gave Moser one final warning. From this point forward, every decision matters. He needed to ask himself one question before doing anything. Is this something that could potentially result in me going to prison for 20 years? It was a powerful reminder that while prison had been avoided today, the consequences of failure were still waiting in the background. In the end, this wasn't just a sentencing hearing. It was a crossroads. One path led toward redemption, responsibility, and a second chance. The other led straight back to a prison sentence that could last 2 decades. And Judge Stephanie Boyd made it clear that the choice now belonged entirely to Philip Moser.
And finally, I just got done with a seasonal contract with Walgreens.
Okay.
So I'm looking at another few contracts I'm hoping for a managed service provider like Spectrum or AT&T.
Okay. And are there any drug issues with you?
No, Your Honor.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's a $1,000 fine that will be probated. Restitution, if any, to Noe Lopez and counsel. If there's an issue with the restitution, we can always have a hearing on that.
Yes, ma'am.
There's an affirmative finding of a deadly weapon, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get that, but if you do, 40 of those hours will be waived. If you obtain some sort of certification in your field, the court will consider waiving the remaining of the hours. So that's up to you. I'm all for people improving themselves. So there is to be regular reporting by Zoom or in person. There's to be regular UAs. Probation, we'll do one field visit per month for 2 months. If there's no issue with the field visits, then you can discontinue them.
I'll be there.
Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors, and no firearm possession,
Sure.
and no contact with Noe Lopez and Maria Pena. Probation, is there anything else he needs?
No, Your Honor.
Defensive driving? I'm just throwing it out there.
Yeah.
It's based upon what I've read. All right. Is there anything else you need from the court to be successful?
Certainly not. I really appreciate the certification, that element. That's very helpful. Since I do have funding for that, and I will get, I have intention to renew my my security plus. So possible. Thank you very much.
All right. You're welcome. And thank you for always dressing appropriately for court. I don't know if Mr. Maurer had anything to do with that or not, but I'll give him credit for that.
Fashion is my hallmark, Judge.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right. We can go off the record. So, Mr. Moser, I believe in this courtroom, communication is always key. And when I place people on probation, I'm expecting them to be successful at it. So make sure you stay in contact with your probation officer. And from here on out, everything that you do, you need to ask yourself before making that decision, is this something that could potentially result in me going to prison for 20 years? Okay.
Yes, Your Honor.
All right. Good luck.
Thank you, Judge. May I be excused?
Yes.